Welcome to Substance Abuse and Family Law Court Legal Tools and Practical Realities. I'm Dan Bemmel, and along with April Zonis, I'm co chair of the Beverly Hills Bar Association Family Law Section. Before we get started today, please check your calendars and make sure you're ready and excited for all of our great upcoming programming. Nuts and bolts of business valuation and family law on October 1st. When bankruptcy is filed during divorce, what happens next? Also on October 1st, the doubleheader. Fireside chat with new judicial officers featuring Judge Shelley Kaufman on October 3rd. All you need to know about PPAs on October 14th, also with Judge Kaufman. And then our two flagship events, the symposium on November 1st called Order in the Court, Tactics for Addressing Bad Faith and Incivility, and State of Department 2 on November 5th in person. It's going to be a blast. The family law section is sponsored by White Zuckerman, Warsofsky, Luna, and Hunt. White Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide additional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Today's program is sponsored by SoberLink. SoberLink is a trusted leader in alcohol monitoring, providing innovative technology that delivers reliable, discreet, and user-friendly solutions to support recovery, treatment, and peace of mind. Here's a brief message from today's sponsor.
Create a safe and fair custody environment with SoberLink. Real or false claims of alcohol use can further complicate divorces by impacting child safety and trust between parents. As a family law attorney, you understand the difficulty of proving or disproving these claims in court and need reliable evidence to support your case. The problem is, traditional lab testing just doesn't cut it for family law cases. Lab tests take time, sometimes days, so by the time you get the results, the parenting time has already come and gone. Any delays in alcohol monitoring can cause uncertainty and impact child safety, leaving room for doubt and making it harder to present a strong case in court. You need something faster, more efficient, and reliable. A solution that gives you real-time, court-admissible evidence so you can protect your client's interests and move cases forward with confidence. SoberLink offers proof of sobriety at your fingertips so you can navigate custody cases confidently. With a push of a button and a single breath, SoberLink confirms the tester's identity and sends an instant notification of whether or not they've been drinking. It's compact and discreet enough to be used multiple times a day and has built-in sensors that detect if someone's trying to cheat. Most importantly, it's easy to read the court-admissible evidence of a parent's entire monthly testing history. For nearly 15 years, our expert in-house support team and best-in-class technology have been helping make safe and fair decisions for children and parents alike. That's what makes SoberLink the #1 alcohol monitoring solution in family law. SoberLink, proving sobriety, improving lives.
Okay, thank you, SoberLink. And now on to the program. I'm delighted to introduce today's speakers, and thank you both in advance for joining us today. The Honorable Harry Powazek and Ashley Gurdo. Judge Powazek is a mediator, arbitrator, and private judge with signature resolution, bringing nearly 3 decades of experience on the San Diego Superior Court bench. A former certified family law specialist and mediator, he is known for his expertise in complex custody disputes, including cases involving substance abuse, supervised visitation, and high conflict parenting matters. He has served on numerous court committees focused on domestic violence and family court policy and has been recognized with multiple judicial honors, including the Distinguished Family Law Jurist Award. Ashley Gurdo is a Rising Scholars Network regional coordinator for the Foundation for California Community Colleges. Before stepping into this role in 2025, she co founded and served as the student support specialist for the Transition Scholars Program at Mira Costa College, where she worked to expand equitable access to higher education for justice impacted students. Drawing on her personal experiences and her background in sociology, Ashley brings a deep commitment to dismantling systemic barriers and advocating for policies that restore dignity and opportunity to individuals impacted by incarceration. We're excited to hear what they have to share with us today. Thank you so much for your preparation and spending this time with our bar. Your Honor, the floor is yours.
Well, thank you. I'd like the introduction. It makes me seem important. I want to thank the Beverly Hills Bar Association for the honor of presenting today. I've been a quiet visitor for the past year watching the seminars. They are excellent. They provide a great deal of information, especially regarding family law, which is an important area for me. If you need to get a hold of me and email me, my email address is Powazek, Powazek at Signature Resolution. I'd be happy to respond to any questions regarding this seminar. Um, we have a lot to cover between family law and substance abuse. There's a lot of things to deal with. Um, and I'm not sure we have enough time. I'm going to try to get to it as quickly as I can and get through as much as we can. Ashley will tell you, I'm old school. I could barely figure out how to use my computer. So rather than having a PowerPoint, I've given you a couple outlines that I thought would be beneficial. Outline what I'm going to be talking today. There's an article I wrote for the LA Daily Journal recently about this particular issue, and I did not know they were going to be a sponsor. There's some handout for SoberLink. Um, and that's a program I'll talk to you in a little bit. A couple disclaimers. I've been retired about 18 months. Sometimes I fall back in the position of thinking I'm a judge, still on the judge's bench, and I say, this is the order I'm going to make, and that I'm retired. So excuse that. I also need to tell you, this is my own opinion. I'm going to give you a bench perspective. I have no formal training in substance abuse. My career began as a public defender in the early 80s, and that's when it was glue sniffing and marijuana was not even close to what it is today. And they did not have vaping, it was just rolling a joint. Things have changed dramatically about that, and I'll talk to you about that in a little bit. I became a certified family law specialist. Family law became my vocation. And then I got on the bench in 1995, and I was on the bench for almost 30 years, primarily in family law. And I retired about 18 months ago. During the same time, I fell in love with my drug court program. Drug court, if you don't know, is a diversionary drug court. They're taken out of the criminal justice system and given an opportunity to get sober, straighten out their life, and move forward. It's a difficult, intensive program. It is supposed to last 18 months. It lasts more than 18 months. We had one lady in there for 8 years. I didn't want to let her go because I knew she would relapse as soon as she got out, and she did. The program requires, and it's usually a felony, it's changed a little bit now, but they had to see me once a week, depending what phase they're in. They had to go to counseling on a regular basis. All my counselors were phenomenal. They were ex-addicts, and so you couldn't really mess with them. They had to be tested regularly. They had to go to school or get a job, and they had to behave themselves. Um, what was really important is the group dynamic, and I'm going to talk to you a little bit about that in a little bit. The group dynamic helped people get sober. They joined the drug court family. It became a safe place for them to deal with their issues. And although their motivation when they first came in was just to get out of jail, you know, drug court's easy, we'll just get out of jail. And that wasn't the case. It took them a while to be comfortable to get into the drug court family, but it was a very successful program. The reason I'm telling you about this, because there's different means of addressing sobriety. Mine mainly was drug court. This is where I learned about substance abuse and the people and how to deal with it, how to hear things that were nonverbal. Most importantly, I got to see people get out of canyons that they were living in and began to get their families back together, to get jobs, to become tax-paying people. And if they completed the program, I had the honor of terminating their probation, restoring their Fourth Amendment rights, and sending them on their way. Although they kept on showing up at our graduations, so I could see how they were doing. As you know, substance abuse has changed tremendously within a very short period of time, and it continues to change tremendously. The delivery systems, the vaping right now, to the various substances, um, the substance abuse issues right now can cause death easily. You know, you have your fentanyl, you have marijuana. That is not what it was when I was in high school. Um, the potency is tremendous. You have the designer drugs. You have drugs they can't even test for now. The bath salts, the Creighton seems to be coming back. Um, and this is no longer a barrio issue. These are issues that are affecting affluent areas of town. Young kids are getting into the pills, and unfortunately, if they take one pill of fentanyl, God bless what's going to happen. In family law, the substance abuse allegations is very common, as you know. When people break up, they grab onto things to try to get an upper hand. They want to try to keep what they have, including their kids. And this provides a very difficult decision for the court for a variety of reasons. From the court side, there's a lack of court resources to deal with this particular issue. There's a lack of family court services resources to deal with this issue. More importantly, the parties generally don't have the money to pay for the tools that I'm about to give you that we utilize. They barely could afford the attorneys, and then you ask them to pay for a substance abuse assessment or an evaluation or testing. It's a very difficult situation. The major problem is when they don't come to an understanding after all this testing, it gets sent to a long cause matter. And in San Diego, when I was in a long cause department, it would take 18 months to 2 years to get to me. And God knows what happens in family law in 18 months to 2 years. So that is some problems within the system itself. I assume everybody understands the main issue is not the use of a substance. It is its effect on the party's ability and skills to take care of their kids. And then balancing that with the safety of the kids as well as their parental rights. It tends to be a moving target. The cases usually show up on my calendar, my old calendar. I'm sorry, I thought I was a judge again, on an ex-party basis with no notice to the accused party. And they're asking for substantial orders as to custody visitation, usually with a domestic violence matter or through an RFO. And it would be great if they provided supporting information to support their request, police reports, videos, pictures. I don't get that. Or normally I didn't get that. What I got was just a declaration basically saying the other party's using drugs, alcohol, the kids are in a bad place, you need to limit access to the kids. And then I set an order shortening time so we could deal with the matter quickly. It was always nice for me when the accused party never showed up. And as long as there was service, I made appropriate orders that I felt were appropriate, and the case moved on. The hard part is when everybody showed up. It was always nice if they had lawyers. Most of the time, they did not. And then what I wanted to do is try to keep the case in a stable place, safe place for the kids until we were able to get credible information. And that was difficult to do. I felt like I was shooting in the dark. It's hard to deal with credibility with people from paperwork because it was usually on a motion calendar. And all I wanted to do was create stability and use the following tools to do that. Now, the tools that I would use are mainly in the handout. Hopefully you have them. I think you should be able to download it. And I'm going to go over them just a little bit because they're important. This is what I would basically use to get through this substance abuse issue, hopefully on a quick and timely basis. There's the California Standards of Judicial Administration 5.20. If you would like to, it's 18 pages long. It's difficult to read through. It's not an easy read. This is regarding the standards regarding supervised visitation, which I use on a regular basis. It applied to professional supervisors and non-professionals. It provided, frankly, what I thought was minimal education regarding substance abuse, child abuse, sexual abuse, domestic violence. There was also a component to learn basic family law. And again, I would use this and be creative with it to try to get some stability, to get access, whether if it's really bad, it could be through the FaceTime, that type of thing. But you could get to be creative with it. The problem with professional supervisors, I don't know around here, but in San Diego, the quality varied tremendously. I would get people who would provide reports to me that were out of their lane, for lack of a legal term. They would tell me what to do regarding custody visitation, and that's not what I wanted. I just wanted to know how the visitation went, how the parties behaved, whether they showed up in time, that type of thing. It was also a problem when they began to be personally involved with the case, especially for the non-professional supervisors. And then there's the cost of it. It could vary tremendously depending on whether you're using a professional supervisor and each of the professional supervisors. There's California Standard Judicial Administration 5.30. This is for the new judges. I don't know in the various jurisdictions you're in, but being in family law for almost 30 years is not happening. They're putting brand new judges in family law, and they're trying to learn the law, and they're trying to learn how to be a judge at the same time. Trying to deal with these type of cases with the little education they're getting is difficult, and you need to be aware of that. I'm assuming you are. I'm going to talk a little bit about that, judges in a little bit. I'm going to say this a lot. This is going to cost a lot for the parties. There's very little resources for them to get the evaluations and so forth. And again, most of them take a lot of time. I've had them take up to a year, depending on the cooperation of the parties. We have court order custody evaluations, 5.220, the California Rules of Court. It's 19 pages long. And it's supported by Family Code Section 211 and 3117. The evaluators must consider the history of child abuse, domestic violence, substance abuse, mental illness, and so forth. And usually when you get these reports, they can vary tremendously depending on the evaluator. Hopefully you're going to get someone who has experience in this area of substance abuse. Some don't. There are some programs that aren't bad that have interns do everything, and they're reviewed by a psychologist. That's usually through the clinics, through the various colleges. I read the reports. I never took anything at face value, whether it was a custody evaluation, whatever. I needed to make sure it was based on more than testing, that they were able to get decent information from all sources, from the parties, the grandparents, family members, teachers, friends, and I'll use that in quotations. That was important for me. There's California Rules of Court 5.225, 19 pages long. It provides what is necessary educational wise for the evaluators, the effects of divorce, separation, domestic violence, child's sexual abuse, children's physical, emotional abuse, neglect, substance abuse, and so forth. Everything that you think would be necessary. But again, if you're going to select evaluator, make sure they have some experience. I understand the cost, but to get me someone who has no experience and the report is minimal at best is not really helpful. Not my favorite thing for a variety of reasons. It's the appointment of minors counsel based on California Rules of Court 5.242. It tells you what the qualifications are. It's 16 pages long. It's recognizing, evaluating, and understanding evidence of child abuse, neglect, family violence, everything that we talked about. Minors counsel, from my perspective, would give me, the court, quick information as to what's going on. Usually, I don't really give a whole lot of credibility for what the parties are telling me because they're so different. They are able to give me quick, hopefully objective information, and it provides a safety net until I get the evaluation or substance abuse assessment or so forth. The best part of it is I'm no longer a target by the parties. I am no longer Satan. I am not making decisions. The minors counsel becomes the target. And sometimes it gets pretty intense. They want to get off of the case. There's not a lot of money for them to get paid. There's a county rate that is abysmal, but at least it's something. There's times that they do have resources. I've made orders for payment and they never comply. And minors counsel doesn't file any type of collection action. But I love minors counsel. The problem is sometimes they get personally involved after they've been attacked personally by one or both of the parties, calling them Satan or incompetent or so forth. It's not an easy job, but frankly, it has helped me until I'm able to make a final order. There's Family Code Section 3041. And by the way, this is all preponderance of the evidence, which makes it less of a burden. 3041 is regarding testing. And we're generally talking about drug testing, urine, or blood testing. There's many types of orders that could be made as to the various labs, various times, various costs, various methods. You should know that I cannot consider, in the past, when I was on the bench, I could not consider hair follicle testing. I loved hair follicle testing. It could provide a great deal of information as to what substances were used, when they were used. The problem is it's not past the Kelly-Fry test. So it's not admissible unless the parties stipulate to it. As a story, I had one litigant that the party stipulated to the hair follicle testing, which was great. And I set it for a review hearing. And then I got a notice that they couldn't complete the testing because the father decided to shave every hair on his body. And I questioned whether it was every hair on his body, and it was. I had to make a test, an order he couldn't shave so they could do the hair follicle testing. And frankly, when they did something like that regarding the noncompliance, it was like strike one. You just don't do that unless there's a reason to do that. There's very creative ways of getting around the testing. I'll talk about that a little bit. There's Family Code Section 3118, where custody evaluation is mandatory. This is 17 pages long. It is ordered when there's serious, credible allegations of child abuse. And it could be sexual, it could be neglect, and so forth. There is the ability for the court to order personal counseling. And I found this helpful at times, depending where the parties were. And I could also order for the kid. I could order family counseling, which I never did. because putting them in a room together was just not going to be a good idea. It's pursuant to Family Code Section 3192. Again, it's court order counseling is to the best interests of the child or children. It required a licensed mental health professional. I kept on having people come in with church counselors. They would go to their church and get information and get a counselor. That would be wonderful. They were never licensed by the state, and I could not really consider their information. It was well-meaning, may have been good, but it was not admissible into evidence. They needed to look at the experience of the mental health provider. There are a number of them that have experience either personally or professionally with substance abuse. The ones that have personal experience I always loved because they could read between the lines what the parties were telling and could get the nonverbal communication that I've learned to pick up on. It gave me a decent report as to where the parties were in their lives and their substance abuse. There is Family Code Section 3011. Again, it just tells the court it must consider a history of abuse in child custody and visitation matters. It was sexual abuse, substance abuse, and so forth. With the really bad cases, and in 30 years, close to 30 years, I had a number of them in which both parties were horrible. I couldn't find a third party to place the kids. Most of the time, the kids were using too, and they were problematic. And the family court, from my perspective, didn't have the capacity with its limited resources to help the parties. So under the 300 petition of the Welfare and Institution Code, I would make a referral to juvenile court. And I did this 3 times in my career. Juvenile court would do an investigation, do a report, and they never took the case. They basically said the family court had the resources and the ability. I think they were overestimating my capabilities to handle the case. And I was livid because I would not send it to them if I thought I had the ability to do it. But that is an option that the courts have. I'm not sure how viable it is in your jurisdiction, but in mine it was not. I need to remind people, it'd be wonderful if substance abuse could be shown on an X-ray or MRI, right? So we didn't have to do this dance. It's not. And it doesn't show up on one particular test with everything at the time of an evidentiary hearing. We'll talk about that. It becomes you throw everything in a bucket and you have your evidentiary hearing if it goes there and you make the best decision you can. There are drug assessments that can be done. They're relatively inexpensive. They can be done in 30 days. I didn't find them to be really helpful. Some were okay because they would just generally do testing and contact a few people and tell me if there was some issue. They would also tell me what I should do with custody visitation, which is outside their lane, and I basically ignore that. But that is an option. I didn't find it that helpful. Regarding the testing, I mentioned it to you in a little bit. It's urine, blood by a licensed lab. You got to be creative with who could do it, what drugs could be tested for, by the way, to limit the cost. There's a problem though. The parties would go, and Ashley could tell you about this, they would go on the internet and how do I get around a test? And the old days, it was a Wizinator. I'm not going to tell you what that was. You could look it up, but there's constant internet input on how to get around the test, whether it's blood or urine. It became problematic. Most of the time, quite frankly, it didn't work. But when you have a substance issue, you would try anything, quite frankly. Prior to the evidentiary hearing, we would talk about that. I began to know the parties on a regular and consistent basis because they would see me on an ex-parte basis saying there's not compliance with the test, or there was a positive test, they're not complying with the assessment or the evaluation. It's like let's go see Judge Powazek. There's nothing better to do to try to deal with us on a regular and consistent basis. Um, with minors counsel, I want to go over it a little bit again. It really helped, but the cost was a problem and the quality was a problem. Every once in a while, I would have minors counsel come in on an ex-parte basis and give me credible information that Child Welfare Services was involved. There's a police investigation and so forth. As to the counseling of the parties, I talked to you a little bit already about it. Licensed, not a church counselor. It could be the parties, it could be the kids, it could be family counseling. Some of it, according to the code, could only be up to a year. Um, but counseling was sort of helpful. Now the one thing I loved, and this is only for alcohol, and I did not know they were going to be a sponsor. In the old days, they would have the ankle bracelets to detect alcohol, and there were ways of getting around it. Now there's SoberLink, and I've given you a handout. If it's just alcohol, the cheapest way, and I'll get into the costs in a little bit, is the SoberLink. They blow into something. It's hooked up to their cell phones. There are test results that are easily downloaded. The information I always got for SoberLink were credible, helpful, and I don't think I ever ignored it. They would use the breathalyzer again. It would be linked to their cell phones. I didn't know this, but it has facial recognition now. It didn't in the past. So if they had someone blow in for them with the facial recognition, that's not going to go anywhere. And that happened in the past when I was on the bench. It's really impossible to cheat. The documentation is quick and easy, and it has modified testing. The costs are between $135 to $235 a month, which, given what an evaluation would cost and so forth, I found that highly appropriate. But again, it's just for alcohol. If they're polysubstance abusers, then I'm not sure how helpful it will be. There's a new thing going on, and Ashley may tell you about it because we got creative in my drug court. We brought down medically assisted treatment, and there's various types of it. There is Vivitrol that we brought down to the drug court, which is an injectable, which blocked the opiate receptors. Did some other things too. But it's not a cure-all. I was watching TV the other day. There's some TV commercial now about a shot that could help with alcohol. I have no idea what that is, but it's advertising. You should be aware of that these are just tools. Using something like this without an appropriate program is worthless. It really is. It has to be part of the treatment program. But it was very interesting when I was talking to the people who started to take the Vivitrol shot, which was good for 30 days. I asked them how they were doing. And they said they were doing fine, except the needle was very long. And that was the bad thing. The good thing, it was they weren't dreaming about the substances at night. It gave them some peace of mind where they could be amenable to treatment. And I thought that was very helpful. The last thing I could do, which was more or less a threat, was placing the child with a third party. If both parties were just horrible, I couldn't get them to cooperate. I thought they were a detriment to the children, and I'd have to make that finding. I threatened to place them with a third party. That's the good news. The bad news, there was nobody. I couldn't find a third party. At best, there will be elderly grandparents who are in their 70s who could not take care of these teenagers usually. So that was more or less an empty threat, but that was an option I had. The goal I had, the reality of the situation, was to get reliable, decent evidence or information that could support a finding or not support a finding that the party's substance abuse affected the parents and they were a danger to the kids. Usually when I got all this information, the evidentiary, the evaluation and the reports and so forth, everybody wanted an evidentiary hearing. Well, not everybody. Sometimes they looked at it and said, we've been through this stuff. And they reached a stipulation at a review hearing that I said, God bless you. We'll see you later. Have a good time. Of course, I came back in about 60 days with an ex parte basis that something happened. That was the reality that I was seeing. But
Judge
most of the
Powazek?
time, I had to set it for an evidentiary hearing. And the time frame to get one in San Diego was 18 months to 2 years, you know? And again, God knows what could happen during that time frame. What I had to be aware of is that no cases were the same. There was not a pattern. One party was using, both parties were using, and one party decided to get sober. The ages the kids were important to me. Half the time the kids were using. It was not unusual for them to be using with the parents. The grandparents became involved. A lot of times they placed the kids with the grandparents, and now the grandparents wanted to join in, and the substance issues came up. I had CPS involvement that would come up because a mandatory reporter, whether it was a doctor or teacher, somebody made a report and they became involved. I had involvement of the other family members, brothers, sisters, and then there were the friends. And I put that in quotation. Sometimes the friends were people that the parties used with. They became problematic and they wanted to be heard. This caused me to learn to use the phrase until the evidentiary hearing came up. I had to learn how to dance, you know, because the music changed, the fact patterns changed on a weekly basis. You know, they would come in with information, and all I wanted to do was keep everything stable. But that was a problem. I had to learn how to dance, for lack of a legal term. It also applies to your judges. You got to know your judge. It's extremely important. You're not going to have somebody like me, 30 years with drug court experience or some history. You're going to get a judge, at least in San Diego, who's just been appointed to the bench, brand new, you know, learning how to be a judge, learning the law, being able to deal with what's on an RFO with multiple issues as child custody, visitation, support, interim orders, and the substance issues jump up on them, it's going to be a problem. Check their history. Maybe they were a public defender who dealt with substance abusers. Maybe they were a DA, you know, something who had some experience to deal with this particular issue. If they were a civil litigator, you're going to have to learn how to spoon feed them because there's a lot of nuances in this particular area that are important. So you have your hearing, you have your evidentiary hearing. Great time. It's 2 weeks long. Everybody came in and testified. Most of them gave you the stink eye because they didn't think you knew what you were doing. And if I made a finding that the allegations were false, which happened, not often, but happened, there would be severe consequences. I strongly would consider removing that child and placing it in a third party or do something and limit the accuser's access to the child and make appropriate, what I call probationary orders, although this is not a criminal matter. If I made a finding that there is a danger to the children as a result of substance abuse, um, I'm going to make certain orders, um, and I'm going to move slowly. I don't want to make any quick orders or orders that I think are not appropriate, um, given the circumstances of the parties, the kids, and so forth. You know, if he hadn't seen the kid in a long time, and now I'm not going to order unsupervised visitation. And we're going to talk about that in a little bit. Um, I'm going to move cautiously. And frankly, and I think the judges feel this way, there's something in the back of our minds where we don't want to see our names on a newspaper article in which a child was hurt because we made orders and they became injured. You know, fortunately, that never happened to me. I was very lucky about that, but um, I would move cautiously. I would set regular review hearings. Most judges won't do that. I wanted to provide them a path to a normalization of a relationship with the kids. Um, and I would make orders depending on the case, and it varied tremendously. I would order a substance abuse program that either inpatient or outpatient, whatever the attorneys were able to provide to me. Um, and it would be, I want information as to the program. I don't like video. There's a group dynamic that is really important. So I think the in-person programs are the best. I had one person came in at an evidentiary hearing and provided me documentation of the program, which I thought was really good. I even put her counselor on it. And as soon as the counselor, I asked the counselor, what is the goal of the program? And she said, it is to reduce or have reduction of this substance abuse. And I go, really? No, no sobriety? No, we're not going to do that. Well, how do you do your testing? Well, we send them a kit and they provide a urine sample and then they come back to the camera and show us the sample because there's a temperature gauge and there's various testing on the container itself. I go, well, how do you know it's her urine? Well, we don't. We just assume she's telling me. I mean, this is a substance abuser that I've been dealing with for years. And I found that the program was not sufficient. So provide information for your client as to a decent program. I may continue supervised visitation of some type. If things are decent, I may just order supervised exchanges in a public place. For some reason, I kept on picking McDonald's. And depending on the age of the kids, I would not have them leave the car. So it was just an exchange, a quick exchange, but it would depend on the case. It's hard to do that with young kids. I would order AA meetings or some type of substance abuse group meeting. It's important. It gives the parties a safe place to talk, to see what they're going through, what the people around them have recommended. The group dynamic is just such an important part of getting sober and addressing the situation. The meetings are all over the place. They're free and easy to get to, generally speaking. That would be an important part of what I call my probationary terms. I may continue the counseling. It just depends what shakes out from the hearings. At the review hearings, by then they're probably representing themselves. Usually they're showing me documentation of what I've ordered. I need to make sure it's credible. It's detailed. It gives me some information as to where they are in their program, either their counseling or substance abuse program. If they give me something that checks the box, I set another review hearing and have them come back with something decent. I need to make sure that they're making concerted efforts to change the people they hang around, where they lived, and various things. I love when they tell me we moved, I'm in a different area. Here's my new job. I'm doing really well. I tended, as Ashley will tell you, is to talk to people. Maybe that's not a good thing or not, but because I was dealing with them on a regular basis, usually you could see a substantial change in their behavior. I'm not Satan anymore. They're not looking at me with a death stare. They look good. Their physical appearance has changed. When I ask questions, so got any tokens? And they respond quickly and concisely. Tell me about your job, how the kids are doing. You can see a visible change. And that is helpful, especially when there's a modification motion being made. After a full-blown evidentiary hearing, I usually make Montenegro orders, Montenegro versus Diaz. For me to change the orders that I made at the evidentiary hearing, I need a significant change of circumstances. Otherwise, it's still best interest. I don't think of a time that I did not make a Montenegro order after a substantial hearing. And then we deal with the modifications because they're going to come back. As I said, I became, I see them on my calendar that I pre-read and go, here we go. Hopefully they're doing okay. And I look at this information. And if it's credible that I've seen a change, then I am inclined to modify the order based on the information. It's going to go slowly, like I told them. But whether it's lifting the supervision, increasing the time for unsupervised visitation, maybe supervision not overnight. It just depends on the case. Sometimes, believe it or not, and it happened rarely, but the parties would call me up and said they've reached a stipulation. They don't need me anymore, which made me a very happy judge because trying to make these decisions, I didn't want to wake up at night in the middle of the night wondering whether I did okay with these kids, whether it's going to be in the newspaper the next day. For the attorneys, if you're still on the case, you've heard what I said, providing credible information as to where your clients are. Keep their expectations reasonable. It's hard for me because I'm going to make orders that they did not anticipate based on what you've told them. And then they're going to look at me as Satan, or they're going to look at you and say, how good are you? Why didn't you anticipate? Judge Powazek, we know him, this was easily anticipated. And the best thing, after the evidence hearing, I don't want to hear the following. Well, I hear it, but I'm not going to give it a whole lot of credibility, and you're going to get the death stare from me. If I'm still on the bench, I forgot. Do not say that's not fair. I had to make a call on what I was given. And if you disagree, there's the appellate process, there's motions for reconsiderations. But if I put a lot of time in it, so that was not something I was happy to hear. The reason I asked Ashley here, because I think she could provide a human perspective on the substance abuse, on the programs, where she was, where she came from, where she is now. She will hopefully tell you about the stink eye she used to give me in the beginning when she got in drug court. But Ashley, why don't you talk to everybody?
Thank you. I want to thank the Beverly Hills Bar Association for the opportunity, and thank you, Your Honor, for allowing me to come and present. Thank you to everybody in attendance. As the Honorable Harry Powazek mentioned, I was in drug court. So I can't speak to the family law side of things, but I can speak to the substance abuse disorder and drug court. And in true drug court fashion, I'd like to say that I have 5,012 days clean and sober today. So that's a little under 14 years. My name is Ashley Gerdo, and, you know, as you can imagine, being a participant of drug court, I had a substance abuse disorder. I think it, you know, through my years of education and coming to know myself and digging deep and learning about why I chose some of the things that I chose, it stems from familial issues. And so I was abused as a child. My parents were teenage addicts when they had me. They went in and out of the criminal justice system themselves. You know, I moved around a lot. I was, you know, in poverty my whole life. And at the age of 15, I thought that I was old enough and grown enough to run away to escape some of that abuse. And that quickly fast forwarded my substance abuse disorder, my introduction to the criminal justice system. And that was a good 10 years of my life. I'm probably an anonymous, what do you call it? Anonymous? I can't say it. I'm probably like one of the only people who asked for drug court. Usually you're mandated to drug court, but I had a glimpse of sobriety in my life in the past when I was a teenager. And so I knew that there was a better way of life. I had heard of drug court before, and I was at the point of desperation where I wanted to do something differently, but it was really hard for me to get away from the lifestyle. It was hard for me because I had never been taught emotional intelligence or emotional regulation, how to identify my feelings, how to unpack the trauma that I had experienced. And so the best that I knew to do was to numb it with drugs and alcohol. I still see my face on the screen, so I much rather look at Harry, because I feel like I'm talking to somebody and not just myself, but I don't know how the webinar host wanted to be. So yeah, so I asked for drug court. I would like to say that, you know, he said it's a minimum 18 months program. I did complete it in 19 months. However, the first few months were really hard for me. I'm taking away the substances, taking away the people that I used to surround myself with. I still had a lot of the criminogenic thinking errors. And that's kind of what drug court was able to help me learn how to process, how to make better judgment and decisions, how to not always be thinking about how I can manipulate myself out of a situation. I was sanctioned. And so in drug court, if you're not obeying the rules, you have to do a weekend in jail. And so that's why I would give the stink eye, because I did do 3 sanctions. And, you know, it was not until the 3rd one that I was able to identify it was my own actions and my own inability to take responsibility for those actions that was causing me to have to go turn myself into jail every weekend. And so on that 3rd sanction is when I made the decision that I was truly going to give my life a second chance, and I was going to do all of the program requirements without cheating or manipulating the system. I did not relapse, but I was just making poor decisions. But drug court literally changed my life, and I'm forever grateful. You know, they forced me to get a job, and so I found a job and I quickly advanced. I was promoted 3 times in my first 90 days probation period. But all of that attributing to learning how to hold myself accountable, learning how to be dependable, how to show up on time, how to do a good job. I had never been exposed to those things before. I did graduate drug court in 19 months. And, you know, when the Honorable Judge Harry Powazek was talking about the counselors, all of the counselors had personal lived experience going through recovery themselves. And so being able to see myself within the people who were guiding me through learning how to change my life was paramount. My counselor was a female, and she was the first female that I ever learned how to trust, because everybody else in my life had harmed me in one way or another. And therefore I learned how to be a trustworthy person. I did go to NA meetings. That was a part of our program requirements, was to attend meetings. And that also changed my life. I'm still active in Narcotics Anonymous almost 14 years later. I still work steps. I don't currently sponsor women, but I have. I'm still very close to my sponsor and my sponsee sisters. And going back to that community was vital for me, because there's a cliche saying that says, that we have to get rid of old people, places, and things. And that was so true for me. When I held on to a couple people who were still living, a dirty lifestyle, I would still be caught up in those, like I said, those thinking errors. So it's a little bit about my journey. I know I want to be mindful of time, so I'll kind of tell you where I'm at today and how I got there. Again, I attribute so much of my success to drug court, to you, Judge P, for not just looking at me as a number on a file that's on your desk, but I'm going to get emotional, but for humanizing me, and for seeing the potential and the worth. I'm grateful and privileged to say that I had 3 children in recovery, and so they have not had to experience me on drugs or on alcohol. Hopefully they never have to go through family law court. The job that I had mentioned before, that I quickly advanced through, it taught me so much, but it wasn't enough as a family of 5 in Southern California. So I put myself through school. I dropped out in 10th grade. I don't remember attending 10th grade. So really I had like an 8th or a 9th grade education. I currently have a master's degree in sociology. And on October 1st, I'm applying for a doctoral degree. While I was going to school, I had such a passion for learning, and I wanted to help everyone around me get an education, because it's really hard when you come from this population to have an affordable living wage with really no education. And so I started the program that they mentioned in my bio. I started a program at Maricosta College in Oceanside, California, that supports justice impacted individuals, creating equitable access for higher education. And from that has just opened a whole new world of possibilities for me, because I've been able to help hundreds of people who come from similar backgrounds that I do, struggling with substance abuse disorder, with homelessness, multiple incarcerations, criminal backgrounds that make it really hard to get into the workforce, to help them obtain degrees and make livable wages. It not only changes their lives, but it changes their families' lives, future generations, their communities. And so it's really, really important work for me. I did run that program for 4 years. I helped many of my former drug court participants go through it as well, getting AA degrees, bachelor's degrees, master's degrees. And currently I have been promoted. And so instead of working for one campus, I now work for the statewide initiative, where I'm working to support the practitioners that are helping the students who are either currently incarcerated or formerly incarcerated, helping them to obtain a higher education as well. But I really do, it's a little bit redundant, but I do attribute this to what I learned in drug court. Having to go through those groups, having to go to court. We didn't just show up to court, we had to dress up for court. Like, we went there weekly, and then as we phased up, we would go monthly or bi-weekly, I forget what it was, but often, we had to meet, and the team worked as a team. So I had never experienced, I was always a defendant in court, and it was like the judge and the DA and then me, and it's like we're against each other. But in drug court, it was a team. And really looking at like what's in the best interest of the client and what's going to propel them in their future. And there were, unfortunately, in my case, there were consequences for my actions, but I learned from them. Like Judge P had said, I'm sorry, I'm really informal, but that's Judge P to me. Like he had said before, when a person is clean and doing well, there usually are patterns. I'm sure that can't be used as like evidence in court or whatnot, but there are usually patterns. People usually start showing up on time. They usually start holding themselves accountable, and they, whatever things that are mandated of them, they're getting done. And like he had mentioned, they're starting to present better. They look healthy, so there are things that, for a person like me, boosted my self-esteem and made me feel valuable and worthy in life. I'm not sure, I know it's 1:30, so I'm not sure how much more time we have, or if there's questions particularly. I know that I think most of you are in family court, and so I can't really speak to that aspect of it, but 10 years substance abuse disorder and 14 years clean. I've got a lot of lived experience, and I'm happy to answer any questions. I'm, again, just really grateful for the opportunity to come and share a little bit about my story, and thank you again.
Yeah, what I just want to point out other than I'm really proud of Ashley and most of my graduates, is the community. The sober community is probably the biggest thing that helps them. You got the counseling, but if they don't feel safe in a place to talk and a place to go to and people they could go to the beach with, you're talking about changing an entire lifestyle and trying to get some of the family court people who come before me or who came before me, there I go again, to understand that without preaching to them, which I cannot do from the bench, is a difficult thing. That's what you have to do as attorneys to get them into these programs that provide this type of support so they feel comfortable and are able to reunite with their families, their kids, and not worry about a police car behind them because they got pulled over. Daniel, is there anything else? Suzanne?
We did actually have two questions, primarily for you, Judge Powazek.
Okay,
Powazek, sorry.
that's
Um,
okay.
from one of the questions is from Nikki Brown asking, what kind of evidence would you look for that a parent has a substance abuse problem that can or does affect their ability to care for the children to support an order to drug counseling, assessment, supervision, etc.?
Great question. And it's a variety of things, whether they've lost their job, whether they're living with their parents now, something that shows a substantial concern regarding their behavior and their ability to parent. Um, like I said, it's always nice to get a police report, that type of thing, pictures of them utilizing the illegal drugs, that type of thing. But it's not an X-ray. It's hard to tell. That's what the evaluation and the substance abuse assessment can provide some type of credible information. But I would look for some real documentation showing that the person's people, place, and things is not good and they're going downhill.
All right, thank you. And then it looks like we have another from Alexander Verducci. What process do you use in trying to match the appointment of minors counsel to a difficult case where neither party is represented by counsel?
Yeah, Mr. Verducci should know this because he was minors counsel in front of me. What I'm supposed to do is sort of list and pick the next person on the list. Now that I'm off the bench, I could tell the truth. There were certain minors counsels that were incredibly effective, incredibly dedicated, um, and somehow they got appointed to certain cases. Mr. Verducci was one of them.
Okay, and then Rachel James asks, how do you deal with cases where one party denies substance abuse when you don't have a DUI or any criminal involvement?
Great question. I don't know. That's why when they come in on an ex party basis, I am looking for some credible information. If it's just a declaration and says something, well, I fear for my kid's safety, because I think he's using or that type of thing, it's a problem. I could order some quick drug testing, um, maybe even hair follicle testing if the parties agree. But other than that, it becomes what I feel is appropriate or not, if that makes sense. I would need some credible information, hopefully contained in the declaration or some pictures, videos, police reports, something. Family members or friends who say, I was at this restaurant, he was blasted, you know, and he drove away, that type of thing. Any information that could be produced that shows that the children are at risk.
All right, and it looks like we have one last question from Robin Wood. Does a client need to have a criminal case in order to get into drug court?
Yes. Oh, no. It needs to be a criminal case. Yeah. Yeah. And drug court, so everybody understands, has changed tremendously since I was there. There are a number of legislative changes that I won't get into because I'll turn into a cranky old man because I had problems with them. But there are other programs around that, through various charitable institutions. You got Brother Benno's, depending how it is. You have a number of charities out there that will help. Salvation Army is a decent program. We used to send people there initially so they could remain in the program. So they understand the part, people understand also. And Ashley mentioned that because she went to jail a couple times. I did not like terminating people from our program. Ashley will tell you, we took in all sorts of people. There's limitations regarding violence and so forth that I would not take into the program, but they remained in the program unless they did something really dangerous and hurt the program. I had one person who didn't have a license, drove, got drunk, went through a police, almost killed him. He was out of the program. But that was very rare. We kept people in our program as much as possible. But check the various Salvation Army, Brother Benno's if you're in San Diego. They provide a decent place to stay and a program.
Great, thank you. So that's it for questions today. Yeah, so it looks like that's it for questions today.
Okay.
Thank you so much, Judge Powazek and Ashley Gerdo, for your time. And thank you so much to our audience for joining us today. Have a
Thank
great
you.
afternoon, everybody.
Ashley, stay well.
Thank you. You as well. Thank you all for your time and the opportunity. I appreciate you.
Bye-bye.